promote yourself as a medico-legal consultant. Let your world know about the same. Once they know, definitely they are going to come out which they are facing, issues which are they facing. And you get an opportunity to get more learning in. Many of the time with your theoretical knowledge, you can definitely guide them, help them to understand the law, support them. But wherever you get stuck, do call us, hold that particular patient or hold that particular client for some time. After taking all brief history, you can call us, share the issues with us. We will put our inputs in that. And you can call back to your client and support them. In all this bargain, you will learn more, and it is action oriented. Like all other field, this field is also like that. If you have handled one scenario situation, you'll be able to handle the same scenario situation again if it comes with someone. So put your knowledge in action. I'll give an example. When I've started my career in this line, I was like you only. I was not that lucky that there was a godfather or a guider to me. But still, when I started promoting myself, lots of questions start. And I need to search an answer for the same. Many time I do called advocates also to get the answer when there's a legal hassles. I do call few of medico-legal experts who are in the field to get the answers. Some practical aspect with various people. But in that bargain, I don't know when I started taking care of all my clients, answering them. And today, also I don't say that I'm perfect, but yes, I can handle majority of it. Example of today's morning, I got call from one of the hospital at Karnataka. Patient approached them at 12 o'clock. Gynecologist was called in emergency because it was a full-term baby. When she has done scanning, she found it is IUD, was already died. Which was well informed because by the time this lady reached, maybe there could be multiple reasons of death. But death in home become foreign body, which was well explained to the relatives. With all consent, midnight surgery was done, cesarean was done. Planned, it was naturally elective. Morning it was done. Now the question came of disposing of the body. Of course, you also going to get such calls. Now the question is that what next? Because it is full-term baby. As per the law, it need to be disposed of properly. It need to be taken to crematorium. It not dispose of like waste material. They need to take to crematorium. They need to do all the procedure which they do in novel court. And for the purpose of same, the death certificate is required. The question was that, sir, what we need to do? Are we are supposed to give a death certificate? Or what? Ask yourself what would be the answer to this. Put your mind in that. If you want to guide a client, you are going to suggest them how you are going to handle where your client gets satisfied and also been protected by the law. Think what word need to be written. Because every word has been examined in the court of law, which is an part and parcel of medical record. Ask yourself, if such a scenario situation, what you are going to guide to you. These are not a one. Like this, many of the questions you're going to approach. A 14-year, 15-year girl approaches to gynecologist with 7-month pregnancy. As with the question of a gynecologist, what she need to do, because 5 months plus, 6 months plus, unmarried girl, child of 14, 15 years, unaware about the fact about their menstruation period, approaches with 6 and 7 month pregnancy where termination is not possible. What you're going to guide to your person, how you're going to handle the scenario under the POSCO law, under the MTP Act, and how you can rescue a doctor if at all such a patient already came and gone, and later you got a call. It's not only a question of medical certificate. I got a call from one of the doctor whose matter was an MMC, 70-year-old, very senior practice, given a certificate of rest to the patient for 9 days, from 4th January to another 9 days. Doctor also don't remember because it is 70 years of his practice that he has given certificate when. But when I inquired, he said, sir, I have given on 4th only, being a Monday, Saturday, Sunday, I have not given a certificate, Sunday is my close. Probably this patient would have submitted to this to their authorities. May have managed the clerk, we don't know because it's a government authority, corporation, where on record the certificate was submitted on 2nd January. It's quite possible that patient may have used influence and put a date of 2nd January on the record of food corporation. There is also possibility the doctor may have given on 2nd mistaking of 4th January may be being a Saturday. Sunday he was not supposed to come. He thought that patient is going to submit on 4th January and given on 2nd January with the date of 4th January. But the food corporation, when examined, they found that this post-dated certificate was with them. Initiated inquiry. Finally, they have sent a letter to NMC, which was forwarded back to NMC, but saying it is unethical practice of giving a certificate before date. That's very typical situation. What you need. I've already guided, which I have shared with told doctor to understand, even if you're given on 2nd. I know it is very common in North that we get influenced with the people and thinking that Monday morning he need to submit. So we give on Saturday with the date of Monday. Very possible. It's not that it's my doctor's fault, but they always do in good faith to save the time of the patient also, genuine patient. But patient don't understand. Instead of 4th, if you have submitted 2nd, next week you're going to be responsible for that. The same story which I narrated to you, I have guided to a doctor that you take the stand of 4th January itself. Whatever you have done, you stick to that, to your reply to that. And then you can give a presumption, the possibilities while defending yourself. There could be a possibility that patient could have managed someone and submitted on 2nd, which I am not aware of. It is their duty to inquire, and my side, it has gone on 4th only. Well, I was knowing that it's going to be warning only. But you need to use your mind while guiding your client in scenarios. And that is a sign of good practice or medical. Second part, which I have shared in all sort of sessions which I have taken multiple times, that we are lucky in this country that law allows us to practice in the courts, which is known as quasi judicial bodies, without having a bar registration or LLB registration. You all are a lucky crowd that today you can defend your client in consumer court and medical council also as an authorized representative. Authorized representative means you do not have to be a leader, you do not have to be a, you do not have to have a registration, you do not have to go LLB for the purpose of the same. You do not have to stop your practice, which you're already doing, because if the moment you become advocate, you need to surrender your medical degree. But with addition to that, if you have been given opportunity, why don't take up 90% plus cases of law goes in consumer fora and medical. Criminal cases are absolutely in 5 to 10%. So major chunk of medical law practice you can do with your knowledge. You need to take a call. As authorized representative, you can not only appear for the doctor, but also appear for the patient if you wish to go. There's a huge supply demand difference in this country. Every patient wanted to see a doctor, but they don't get a proper person. Every doctor definitely wanted to get defended in medical law. They don't get a proper person. Experts take advantage of that. Start practicing. We are there to help you in drafting documentation on the part. And I always say to all the learners, your investment of 30,000 is not a big amount which you invested on self, and which with our experiences, not in one case, but in multiple cases in the past, I've seen that people have recovered within 3 months, within 2. If you take a client, if you promote yourself, any single client, put them 30,000 straight. We are there to help. Take the 30,000 fees from the patient. Your fees is recovered, your investment is recovered, and remaining his whole life as earning name, fame. But again, on it's you. Not only that, even if you protect yourself in any medical law without taking help of any other people because of your knowledge, the amount which you're going to pay to the people for defending yourself is your amount, and there your investment is required. But unless you come in action, is going to happen. When I talk about consumer fora, when I talk about legal counsels or a normal court, the secret of winning cases lies with your observation. Because observation creates curiosity. Curiosity creates the motivation of doing research, and research helps you to win the case. But if you're not observant, it will be difficult for you. I'll give a case which was guided by me. It was doctor's family, so I helped them where MTP has happened. Lekuna was being MTP. Wife's signature was not there on a consent. Learned advocate presented to the court that even husband's signature is suffice. Lots of argument done when this patient came to me. Sorry, doctor came to me. I said, in all given scenario situation, your MCI Act, just observe, because it was observation. The signature verification, observation that there is a signature which authentically needed to. And then MCI Act very clearly says that both the partners' signature is required, which has been narrated under also. Helped him to win the case. Great. Orthopedic surgeon whose brother died in hospital, 2 months of admission, was keen observer, being a doctor. In first 7-8 days, bleeding, as per the doctor, team was stopped, but still blood transfusion was needed, hemoglobin was going down, He himself, being a doctor, suggested to do HRCT because he found in one of the X-rays suddenly seen by his RMO and then confirmed by him that there is a refraction. It was ignored by various radiologists and doctors. Found to have a 6 ribs fracture leading to bleeding of the patient. And then he became more concerned in all medical paper. And where at one stage, vancomycin injection was prescribed by the team of doctor 2 grams 3 times a day for 6 days or 7 days. And patient died. He has taken ground of that because being a doctor, he was knowing that maximum doses of vancomycin is 2 grams a day. An overdose of vancomycin, literature shows that causing nephrotoxicity, neurotoxicity, where cause of death is multi-organ failure. It would be able to detect all that. Observe. Become a good medical legal consultant, you need to be observant. Whenever you read a medical report in front of you, be observant. You'll find lots of lacunas which need to be covered up or need to hold to argue the matter. Not only that, but even in the case of even in any cases, once. So be observant. And if you're observant, you will find lots of things to argue the matter. Second important aspect as a secret to win any cases in a court of law is to have a command on precedents. Because our law is like that. Our law says that precedent created by upper is mandated to be followed by lower. The issue is same. If Supreme Court has given some judgment, the Commission has given some judgment, State Commission has given some, all these judgments are binding, having a binding effect on forum. If you got such a good judgment, you all can definitely utilize the same for arguing the matter in a court of law. Believe me, my friend, because of the law of this land, this law of the land, if you can prove that such a judgment has already been on the same ratio, the lower judge, no matter that judgment is right or wrong in eyes of his, have to follow. That's the reason why judgment plays a vital role in law practice.